Well, good afternoon. My name is Brian Benkstein, and welcome to the webinar on strategic use of performance improvement plans, how to develop and effectively implement. By way of brief background, I'm an attorney here at Fredrikson, of course, and I've been practicing in the area of employment and labor law exclusively on the management side for my entire professional career. So in my day-to-day work, I will talk with and advise employers about things like implementation of performance improvement plans, employee discipline, and I also litigate employment-related cases and will defend employers in matters that are brought in the state and federal court system. So the materials that I've put together here are intended to be very practically focused or practically based. My goal and objective is for you to walk away with some information that you can easily implement and improve your processes around performance improvement plans. So by way of brief overview and to provide a roadmap as to where we're going in approximately 45 minutes, we're going to talk a little bit about performance improvement plans just by way of background so that we're all on the same playing field as we talk through the materials. We'll cover the advantages and disadvantages of performance improvement plans. We'll also talk about some of the legal issues that relate to performance improvement plans, but in all candor, the presentation here today is not particularly legal heavy. As mentioned, I really want to try to talk about things that you can implement on a practical level and take back to your organizations. Finally, or in addition, I should say, we'll talk about the phases of developing and implementing performance improvement plans. And then to conclude, there is an opportunity for you all to submit questions. And to that end, good segue, if you do have questions, I understand that you can hover over the bottom of your screen to see a chat feature. And what will happen at that point is your message will come into our webinar center, and to the extent that we can get to those questions at the end, time permitting, we'll go ahead and get some of those answered. To the extent that the internet audio cuts out, please use the dial-in number provided and we can get you reconnected by telephone. So with that housekeeping aside, we'll go ahead and get straight into the materials. So first of all, performance improvement plans, just by way of general overview, what is a PIP or a performance improvement plan? And there's really no magic structure or document that constitutes a PIP. It really can be anything that you want or need it to be in your organization to accomplish a particular goal or objective with an employee. But how I would define it would be a formal document that puts an employee on notice of a performance issue or some kind of, or really any kind of employment-related issue, sets forth a process to give the employee an opportunity to remedy the problem. It's really important that the PIP process be viewed as a process that does take some work on everybody's part. I think it's evident that the employee, as for their part in the PIP process, is going to have some work to do, but it's often overlooked that management also has some important responsibilities in managing the PIP process and making sure that management is doing what it said it was going to do as part of the process. And we'll talk more about that when we get into the development and implementation, but the bottom line is that the PIP process is something that you need to be committed to in order to make it work and in order for it to be an effective process. The other thing I wanted to note out of the gate here is that PIPs, and as I mentioned just a moment ago, because there's really no magic formula or document that constitutes a PIP, they can be simple, they can be complex, and they can address really a variety of issues depending on what your strategic objectives are. And what I mean by that is that, for example, a PIP can be used to address, say, a simple, straightforward attendance problem. A PIP can also be used to address a confluence of issues that are going on with an employee that could range from an attendance issue to behavior issues to work performance issues. And so, bear in mind that the PIP can be used in a variety of different circumstances, and you can get as complex or as detailed as you wish, so long as you're being thoughtful about the process. And again, as indicated in this slide, you want to be strategic about how you're using a PIP and making sure that when you're preparing a PIP and implementing it, it is consistent with your objectives. And the objective could be, in the simple scenario, to improve that employee's attendance. It could be to address that confluence of issues that are going on with a particular employee, or frankly, something in between. So here's just some examples of what a PIP can be used for. And really, I'm not intending to be flippant by the first sub-bullet here, but really, a PIP can be used for anything. Any kind of an employment-related issue that's going on with an employee. I think that, what most people are familiar with and use PIPs for is a performance issue, and that's a perfectly fine reason to use a PIP. And to that end, it can be used to define expectations. It can address specific behavior or conduct. It can address a failure to meet job expectations. But also bear in mind, PIPs can be used to, for example, identify a training gap. Let's just say that you have an employee that is really not functioning in the job up to expectations, and certainly the PIP can be used to address those failures in that regard. But part of the PIP could also address the fact that the employee has an identified training gap and set goals and expectations for that employee to get up to speed, so to speak, with respect to those gaps. So that's an example of a PIP addressing really the overall issue, and it sets forth a way to help the employee get into compliance by, for example, focusing on a training gap. Certainly a PIP can be used to address policy violations, and again, what I think most people are used to using PIPs for is it's a prelude to termination or some other kind of discipline. Before we move on to the next segment, though, and although it's absolutely true that PIPs are routinely used as a final step before termination, a PIP can be used at any point in the employment relationship. And there are certain circumstances in which a PIP can be used effectively before initiating the disciplinary process. Just by way of example, I think that a PIP before the disciplinary process begins can be an effective way to bring an employee back into compliance. It allows the employee an opportunity to get into compliance before he or she is subject to a formal disciplinary process. And when I talk with clients about using PIPs in that manner, sometimes clients are a little taken back by that because, again, I think that there's a presumption that PIPs are really kind of the last stage of the disciplinary process, but that doesn't need to be the case. As I said from the very beginning, PIPs can be used really very fluidly and under a variety of circumstances. And again, so long as it's aligning with your strategic objectives, consider use of a PIP at any stage of the process. And depending on what you have going on with a particular employee, a discrete PIP to address a particular issue before heading into, say, a written warning might be a very effective tool, depending on the circumstances. I want to spend a few minutes talking about what a PIP is not. And this is a common trap that employers fall into, and unfortunately, employers fall into this trap with some level of frequency. A PIP is definitely not a tool that is used as a setup to cause the employee to fail. Another way of looking at it, it is not the obligatory paper trail before termination. The reason why I spend a few minutes on this topic in a presentation like this is that one of the worst things that you can do from an employment perspective is to use a PIP for an illegitimate purpose. And I don't mean using it to discriminate against an employee, to retaliate against an employee, to do something unlawful. What I mean by that is that using a PIP as again, this obligatory paper trail as just something you need to do to check the box before you can terminate someone. And where I see that this most often is a problem is in the lower ranks of management. Supervisors, managers that are in effect in the trenches with employees will often look at a PIP as really that vehicle that they can use to get rid of a problem employee. And what I also will see, particularly in that lower level management group, is that the manager is really hot to trot to implement a PIP when, lo and behold, there's really no other form of documentation in the employee's file with respect to discipline or even coachings or verbal discussions, anything like that. And so what the manager does is that they come forward to HR or perhaps their manager, and the pitch is, well, I want to put this person on a performance improvement plan because I want to get rid of them. Well, again, that's not the reason why we should be implementing a PIP. A PIP, to be effective and to be legitimate, really does truly need to give that employee an opportunity to improve, to correct the performance, and to bring that performance back into compliance. And so one way to look at it is that a PIP really should be viewed from the optimist point of view, and that is that the employee should be expected to improve to satisfy the PIP, and they'll remain employed. Moving on to the advantages and disadvantages of PIPs, and there are certainly some of both, and we're going to run through them. So, advantages. With proper managerial and supervisory training, and I'll come back to that in a moment, PIPs can be a very effective tool to bring an employee back into compliance with expectations. But again, the key, with proper managerial and supervisory training. I find it very common that PIPs are being used in workplaces. Managers, supervisors are tasked with implementing and monitoring and effectuating the PIP, but yet they don't receive any training or, frankly, supervision as to how to manage that process. And that's where I see a lot of problems where managers are jamming through the PIP as, again, that vehicle to use to terminate someone. And again, that's not what we're trying to accomplish. So to the extent that your organization is using PIPs, and I hope you are, frankly, because again, they're an effective tool, it's really important that you do give your managers and supervisors some level of training so that they understand what the process is, they understand what the company's objectives are when using a PIP, so that it can be used, again, to effectuate that purpose that you're looking for. Another advantage with PIPs is that they can and should be precise. Performance improvement plans allow managers to hone in on specific problematic behaviors, and it gives managers an opportunity to explain very clearly what they're looking for from an employee and what their expectations are and what the next steps are. And this is contrasted with the semi-annual or annual performance review, where all of the employees' performance, behavior, and work performance is being evaluated all in one shot. And it's obviously a very broad-based focus. PIPs, on the other hand, you have the distinct advantage of really zeroing in on the problematic behavior, and I think that it lends for a more effective process because that employee is put on specific notice. They can put their blinders on, so to speak, and have a clear understanding of what's expected of them and how to bring themselves back into compliance. I jumped the gun when I'm talking about PIPs PIPs are fluid. As mentioned just seconds ago, PIPs allow you to address performance issues in effect in the moment, as opposed to waiting for a semi-annual or annual performance review. I think that the use of PIPs in between those semi-annual or annual performance reviews can be an effective tool because it really it mitigates against the risk of a manager in effect holding on to all kinds of performance issues for that semi-annual or annual review. And I'm sure that you've all experienced situations where lo and behold, an employee goes into say an annual performance review, the review is not favorable, and the employee maybe rightfully contends that, well, hey, wait a minute, this is the first time I'm hearing about all these problems. Why have I not heard about these problems before? Well, effective effective management, use of PIPs or any other form of giving them a chance to fix it. And ultimately, a document like that can be a really powerful piece of evidence if you ever do find yourself at trial. And so a PIP, the way to look at it is that, if any person off the street picked up that performance improvement plan and looked at the four corners of that document, does it tell a story, and does it tell a persuasive story from the employer's perspective? If it doesn't, I would encourage you to go back and make some edits. Draft it in a way that you can take full advantage of it if you ever have to defend yourself in a litigation matter or at some other point down the road.
It's not a good.
Let's move on to some of the disadvantages, or maybe a more politically appropriate description would be challenges, PIP challenges. First of all, you all should be aware that there is an inherent bias with respect to performance improvement plans. There are lots of people out there that believe that PIPs are nothing other than a disingenuous step before termination. In fact, if you Google disadvantages with performance improvement plans, I will predict that you will find articles that are written on this subject that are talking about how PIPs are really, again, nothing other than a way to set up an employee for failure. They're not used for legitimate purposes, et cetera, et cetera. That negative feedback, or this inherent bias that I'm talking about, I don't think, in fact, I would encourage you not to be dissuaded. Continue to use PIPs, but just make sure that they're used for a legitimate purpose. And by understanding that there is some bias out there with respect to PIPs, I think that it puts you in a stronger position to develop that document in a way that's more persuasive. So just use that knowledge of a bias to your advantage when drafting. Another disadvantage challenge with a PIP is that, again, I highlighted just a little while ago, it's important to train your managers to use them effectively and for the right reason. And relatedly, managers and whoever's using a performance improvement plan needs to understand that it's going to take some work on their part. A manager has to be committed to following through on the PIP, which means giving the employee a real and legitimate chance to improve. Again, if that manager is using the PIP as a way to check the box before they intend to terminate someone, then don't use a PIP. Because I think that, well, I know that if you find yourself in litigation and a PIP is used for an illegitimate purpose, meaning it really was a setup, that will be exposed, and that's something that is not a real favorable fact, because it makes it look like the employer is trying to take advantage of the employee, and it's not being, the employer that is not being genuine and giving that employee a chance. So bottom line, if a manager is not going to use a PIP for the right reasons, don't use one. We'll spend just a few minutes here on some of the legal issues relating to PIPs. And again, I think by having some of this background, it can put you in a better position to more effectively draft and implement performance improvement plans. So first of all, PIPs are what I would describe as an interesting legal creature. And what I mean by that is that most people think that PIPs are a form of disciplinary action that can give rise to a legal claim in and of themselves. And what I mean by that is that in order for an employee to bring, for example, a claim of racial discrimination, the employee needs to establish, among other things, that he or she is the victim of or suffered an adverse employment action, meaning the employee was terminated, They sustained a decrease in pay. They were not given a promotion that they wanted. They weren't given a job that they wanted. In other words, there has to be some tangible action or event that the employee is relying upon to establish that legal claim. And I think, again, in the case of termination, I think everyone would agree that that's an adverse employment action because the employee's out of a job. PIPs, though, are interesting in that the law does not recognize performance improvement plans as constituting adverse employment action that can sustain a legal claim in and of itself. So one way to look at it, a PIP, or one way to look at a PIP is that it's kind of in a way, kind of in its own status. It's sort of in legal limbo because, again, a PIP in and of itself, if you deliver a PIP to someone and the employee claims that it was discriminatory for you to give them that PIP and goes and sues you, the employee, you would have a very strong argument, at least in the Eighth Circuit, that that is not a sustainable claim because the employee did not suffer or sustain any kind of adverse employment action. The PIP did not materially change their employment circumstances in and of itself. The Eighth Circuit Court of Appeals, which is the highest federal appellate court in our area, has also held that an employee's placement on a PIP does not support a claim for constructive discharge. And what we're talking about there is that's a situation where the employee claims that the working conditions were so bad, unreasonable, intolerable, that he or she had no other choice but to quit. And sometimes the employee will attempt to claim that, hey, my employer put me on a performance improvement plan, and the performance improvement plan made my life and my working conditions so intolerable that I had no choice but to quit. Well, the Eighth Circuit has said that doesn't work. A performance improvement plan is not something that rises to the level of a constructive discharge, and if an employee tried to bring a claim like that, again, you as the employer would be on very solid ground to get a case like that dismissed. So there's always some bad news, though. Even though performance improvement plans don't constitute adverse employment action that can give rise to a legal claim in and of itself, even though performance improvement plans can't support a claim for constructive discharge, employees, and more accurately their attorneys, will nevertheless attempt to find a way to use the PIP as some evidence to support a claim. And the case that I have referenced here, the Lifetime Fitness case, the court there was presented with the issue of whether the employee's placement on a PIP could create an inference of discrimination that supported other aspects of the employee's claim. And it's all a long way of saying that, you should be prepared that if you implement PIPs, employees will attempt to use them in some fashion to support their claims. And it goes back to what we were talking about before, that it's all the more important to implement and use performance improvement plans for the right reasons and for legitimate reasons, because if, for example, you don't use a PIP for the right reason and it's viewed as a sham or something that you were using to set up the employee, it can fall into this category of the Lifetime Fitness analysis, and it can be used as evidence against you. And obviously you want to avoid that circumstance. All right, now we get into the phases of developing and implementing a performance improvement plan. So I appreciate you hanging on with me so far. This is where we get into more of the practicalities and the things that you can hopefully use and walk away with and improve your processes. So first of all, the first step when implementing a performance improvement plan is the assessment phase. And it's really looking critically at whether the performance improvement plan fits the circumstance that you're dealing with. You should consider the totality of the circumstances, and you should really think about whether it is the right tool at the right time and you're using it for the right reason. Some of the things that you want to consider, as we've talked about and I've said probably 4 times already, is the PIP being used for a legitimate purpose. I think a relevant consideration is considering the manager who is going to be charged with implementing the PIP. Is that manager using the PIP for the right reason? Is that manager committed to following the process set forth in the performance improvement plan? Is the employer willing or manager willing to do the work that it's going to take for that PIP to be used effectively? I think another relevant consideration is the PIP likely to be effective, or is it going to be a complete waste of time and energy? Unfortunately, there are circumstances where the employment relationship is so badly broken, the employee's performance is just so bad and so under par that maybe you look at termination instead of putting the employee on a PIP. A PIP, again, if you're going into the PIP process with the distinct feeling, impression, understanding, or you're confident that it's going to be a waste of time, then don't bother using it and don't bother doing one. Because I think that there's more that can go wrong by using a PIP in those circumstances than the benefit that you're going to get from it. Another consideration is whether the PIP is a logical step in light of the employee's performance history and tenure with the company. What I mean by that is that, for example, if you've had an employee who has never, ever, in their 15 years of employment, been subject to any disciplinary action whatsoever, their annual reviews are stellar, and in effect, they're a rock star. You have a manager, let's just say you have a new manager that approaches you, you're in human resources or some other position, and says, hey, I want to put this employee on a performance improvement plan, and I want to give them 60 days to improve, or otherwise they're going to be out the door. Well, the warning bells should be going off in that circumstance, because I would argue that a PIP in that circumstance is likely not a logical step in light of the employee's performance history. So that's just something, again, another employee-specific consideration that you want to bear in mind before you go off and implement the PIP. I think these 2 points here are somewhat repetitive of what I've already said. Again, we've got to make sure that we've got the right manager who's committed to seeing the process through. If not, let's put a different manager in charge of the process, or let's not use the PIP if we don't think the manager can effectively handle the process. And lastly, I highlighted already, is the employee-employment relationship salvageable? If not, just don't use a PIP. Don't waste your time. It is certainly worth a quick note here that if you have a policy on issuance of performance improvement plans or other disciplinary action, it's critical that you review the policy and you follow it as it relates to implementation of performance improvement plans. One of the worst things that an employer can do is to move forward with some form of action, and it's just grossly inconsistent with the employer's own policies. Is that illegal? No. But does it make the employer look rather foolish? Yes. Does it potentially call into question whether the employer is being fair to this employee? Yes, it does. So those are things you all want to avoid. The next phase in the process is the actual drafting. And there are some critical components to any effective performance improvement plan. Before we get to the actual nitty-gritty, let's talk for a few minutes about why we're documenting the way we are in performance-related documents, including PIPs. First and foremost, we're attempting to create a record in order to protect against bad memories. To the extent that you, unfortunately, find yourself in litigation involving a current or former employee, from the point in time of the alleged events that form the basis of the lawsuit to the point in time that you're actually trying that case in court, it could be a span of 2 years. And I imagine many of you are like me. I can't remember what I did a week ago, let alone 2 years ago. So that it underscores the importance of creating an accurate document that will not only help refresh managers and other employees' recollections, but also to establish validity in what you've done. And to that end, performance improvement plans have evidentiary weight and value. Imagine the circumstance where you're sitting in a jury and it's a case about an employee suing the employer. You have a witness on the stand, the manager, and they're talking about issuing a performance improvement plan to an employee and the things that they can remember about their performance improvement plan. Are you more persuaded by the manager's testimony if that manager has the actual performance improvement plan that lays out all the things that they're talking about? You betcha. That performance improvement plan can bolster the credibility of your own witness. And it's for that reason that we want those performance improvement plans to be persuasive, to tell a story, and to tell a persuasive story. Because if you find yourself in litigation, it gives your managers or your witnesses on the stand the tools that they need to provide persuasive testimony. There's, without spending a lot of time on this, good, effective documentation absolutely advances your position in litigation. Courts repeatedly cite examples of written warnings, the fact that employees were put on notice of problems, the fact that the employer followed its own policies and procedures. The documents that you're preparing, including performance improvement plans, really can help you advance your defenses of a legal case. And again, it's a circumstance where not only will a good, effective document be persuasive to a jury, but most definitely they're going to be persuasive to the court, and it may enable you to avoid a trial and get rid of those cases before you even get there. I'm going to move past the Brody case. So let's get down to the essential elements of a PIP. Every effective PIP has these elements. First and foremost, a clear identification of the employee performance or behavior issue. We've got to set forth in clear and unmistakable terms what the employee is doing that's a problem, and it could be any number of things that we've talked about. It could be an attendance issue, it could be a behavior issue, it could be a policy issue, but you want to be as specific as possible for the reason I talked about, and that is, in order for your document, your PIP, to tell a persuasive story and to put the employee on appropriate notice of what the problem is, you have to be specific. So be as specific as you can. The next step and the next essential element is that you have to take that behavior or performance issue that you've identified and tie it to the policy or performance standard that's at issue and an explanation of why the employee is not meeting it. Take, for example, an attendance problem. That's probably one of the easiest examples. Let's just say you have a performance improvement plan for an employee. You've identified the fact that the employee's been absent 6 times in the last 30 days. When we're talking about the policy or performance standard, you cite your policy. The employer's policy states that employees may not be absent more than 2 days in any 30-day period, and you've just connected the dots. You've connected the dots as to why an employee's behavior is not meeting the policy or performance standards. The next essential element of the PIP is that you have to have specific, measurable, objective, and achievable goals in order to bring the employee back into compliance. Using that example of the attendance issue, maybe the specific measurable goal is that you, employee, will not have more than one absence in the next 60 days. Depending on some other kind of behavior problem, you're going to set a time frame and you're going to say what you expect of that employee as objectively and as clearly as you can. I jumped the gun again. We want to have clear time frames associated with the compliance goals over the next 30 days, 60 days, whatever you decide to establish as the time frame for that employee to be back in compliance. An effective PIP will also incorporate defined and scheduled what I call touch points with management. And this goes back to the concept that you want to make sure that your performance improvement plan is being set up in a way so that it's fair to the employee. If, for example, you implement a performance improvement plan and it's scheduled to go 60 days and you don't have any scheduled meetings in between, I think most reasonable people would agree that's not very fair. The employee ought to be receiving some feedback on the performance improvement plan at various intervals during the plan. And so you should have scheduled touch points. It's also really important that management follows through with those touch points. It's really, really a problem if, for example, you say in the performance improvement plan, manager and employee will meet every 2 weeks to discuss employees' compliance with the plan and related performance. Well, let's just say, for example, the manager who's in charge of implementing the performance improvement plan just completely blows off those meetings, doesn't schedule them, doesn't follow up on them, and lo and behold, we hit the 60-day point and there's been no scheduled meetings, even though the plan itself called for meetings every 2 weeks. Under those circumstances, frankly, I think management looks foolish. And you've set yourself up for failure because, again, you're not being fair to that employee and you're not even following your own performance improvement plan. Finally, the performance improvement plan has to unambiguously say what the consequences are if the employee fails to comply with the plan. It could be you're going to be put on another PIP. It could be you're going to be subject to termination. It could be you're going to be subject to discipline. There has to be some message to the employee of what's going to happen if they don't comply with the plan. Just to touch on some common drafting errors that I see based on my travels of defending employment-related cases. First of all, sloppiness. You know, I will sometimes see performance improvement plans and other forms of documentation that just have simple, pardon my language, stupid mistakes. Inaccuracies describing prior disciplinary history. I've seen documents where the company doesn't even accurately state or describe its own policies or standards. The facts giving rise to the performance improvement plan are convoluted or inaccurate. Silly mistakes like dates, referencing the wrong policy. Unfortunately, I've seen all of these things, and all of these things I've just described are very easily avoidable through careful drafting and just simply reviewing the document. Another problem that you want to definitely avoid is subjectivity versus objectivity. Here's an example of what you're trying to avoid. There's a statement in the performance improvement plan. The employee has a bad attitude and is absent a lot. Well, okay, I guess we understand that there's some kind of an attitude problem and there's some kind of an attendance problem, but we certainly don't know a whole lot, and we're not really putting that employee on effective notice of what the true problem is. Here's a good example, and this is what we would want to see in the PIP. During the meeting on March 23rd, 2018, employee said to me as manager, "You are a blankety-blank supervisor, and you're stupid." What we say then in the PIP, this behavior violates the company's respectful workplace policy, Section 2A. We also go on to say in the performance improvement plan, company attendance standards require regular and reliable attendance. The company's policy prohibits more than 3 absences in a 60-day period. Employee has been absent 12 times in the last 60 days. So if you look at bad example versus good example, I hope there's no one in the audience that would argue that the good examples tell a far more persuasive story, and that's what we're looking to do. Some other common mistakes is just not setting precise measurable goals. We've got to try to set those performance improvement plan goals as specifically and as objectively as possible. I can appreciate that in some circumstances that's not possible, but for example, even when dealing with a behavior issue, the expectation is the employee is not going to engage in XYZ behavior ever again. Most certainly not during the plan and ever again. Employee will also comply with the employer's respectful workplace policy and all of its terms and conditions. So even in situations where you have a more amorphous behavior problem, you can still get pretty specific when you're setting those goals, and you ought to. And then lastly, failure to identify the consequences. Unfortunately, I see PIPs where it's just silent as to what happens if the employee doesn't comply with the plan, and that's an easy one to fix. So in order to avoid some of these mistakes, you always want to review, revise, and reconsider the PIP. Once it's drafted, review it critically, revise it, and use as your benchmark when you're reviewing that document. It rolls off the tip of the tongue, WWAJT. What would a jury think? If you look at that document from the perspective of a future juror who may be asked to look at that document, I think that's a great way of evaluating whether your PIP makes sense. We want any potential juror, or as I mentioned earlier, any person off the street to be able to pick up that document and have a clear understanding of what the problem is, what the expectations are, and what the roadmap is for that employee. All right, implementation. When you're implementing a PIP, just like drafting the PIP itself, you want to be thoughtful about the messaging. We want to plan what we're going to say to the employee. We definitely don't want to just wing it. And we want to go through and take whatever time we need to thoroughly review the PIP with the employee in order to set clear expectations. However, the meeting to implement a PIP shouldn't take too long. And what I mean by that is that when you're implementing a performance improvement plan, it is definitely not the time to engage the employee or have the employee engage you in a debate about whether he or she has performance problems, whether a PIP is warranted. That ship has sailed, so to speak. Yes, we will talk with the employee prospectively about their compliance with the PIP, but when you're meeting with the employee to put them on the PIP, it's the time to implement the PIP, not engage the employee in a debate. I've covered these points and I won't cover them again. Just highlighting again the touch points, and that's just not going through the motions. The manager implementing the PIP, who's responsible for those meetings that will occur throughout the plan, it's not just going through the motions. The manager needs to be giving legitimate, honest feedback about the employee's performance. And as mentioned before, you have to follow the process that you as management sets forth in the PIP. There are certainly circumstances where during the course of a performance improvement plan that circumstances change. Maybe the employee raises a concern, provides some feedback that's legitimate and causes you to reevaluate your position to some extent. You can always revise the PIP. That's always an option. The goal, of course, is to make sure that it's accurate, that it appropriately reflects the problems that the employee is having. But by the same token, a PIP can't be a moving target. It can't be subject to constant change. It can't be something that leaves the employee guessing about what the employer expects. Finally, just to talk for a couple of minutes here about closing out the PIP. One way or another, the PIP should be closed out. And what I mean by that is that there should be an end to it. I've had clients talk to me about an employee being on a performance improvement plan for upwards of 2 months, 3 months, six months. We're not using the PIP for the right reasons then. Generally speaking, PIP should not go more than 90 days. That's kind of rule of thumb. I would say that another rule of thumb is that generally PIPs shouldn't be shorter than 30 days because if you establish a PIP for too short a time period, it begs the question of whether that employee is really given an opportunity to improve. Just to give you a silly example, you have a manager that approaches you and said, I want to put an employee on a PIP. You ask the question, well, how long do you want to give them to correct their behavior? Well, how about this Friday? Well, no, that's not an effective use of the PIP, and that you're using the PIP for the wrong reason then. One question that I often get in these contexts is that let's just say you do close out the PIP. And that might mean the employee was successful during the performance improvement plan period. They've improved their performance and off they go. Does it mean that the employee is off the hook? Well, definitely not. It is absolutely reasonable, appropriate, and you should tell the employee that, as part of the performance improvement plan, your ongoing compliance and your ongoing improved performance needs to be sustained. It needs to be sustained during your employment forever. In other words, we didn't just go through this performance improvement process so that you could correct your behavior for 60 days and then you go back to your old tricks. That's not the way it works. So kind of going back a step, when we're talking about the drafting, it's definitely appropriate and in fact recommended that you have a statement in there that says, your performance must improve during the course of the performance improvement plan and on an ongoing basis during your employment. And that sends the message that we're not going to tolerate an employee that I guess the analogy I would use has kind of that yo-yo performance where they're in compliance, out of compliance, in compliance, out of compliance. The PIP can be used in a way to put that employee on notice that the behavior needs to occur on a long-term basis. I think we've covered those slides. I'm going to get to a couple of questions here. And I'm just going to jump right in. The question that's come in is, can you explain how a PIP would differ from a written warning or why you would use one over the other? Additionally, would you ever do both of them together, a written warning followed up with a specific PIP? I think this is a great question. And I think that I'll give you my typical lawyer answer, and it depends. And the circumstance in which you would use a PIP versus a warning. I think that I tend to see PIPs used for a broader range of performance issues that there are all kinds of issues. And what I mean by that is that, and I gave you a hypothetical example earlier about putting an employee on a PIP for an attendance problem. Generally speaking, I don't see many PIPs that relate to an attendance problem for the simple reason that most employers go straight to discipline for something like that. Could you use a PIP for attendance? Absolutely. Can you go straight to discipline? Of course you can. So I think that it depends on the type of behavior that you're trying to address. But I would say that to answer the question as best I can, a PIP tends to be used for that confluence of performance issues. It's trying to address a number of different performance deficiencies that may go to the very core of that person's job and their ability to be in that job. So hopefully that answered your question. The second part of the question, do you ever use a PIP and a written warning simultaneously? I don't think that would be particularly common, and I think that you would want to go one direction or another. However, if, for example, you have an employee on a performance improvement plan, and let's just say, for example, that employee just completely tanked during the period of review. And the other advantage of having these kind of mid touch points is that you can certainly reevaluate that employee's performance along the way. So in the case of an employee that was on a 60-day plan that was a complete disaster after 30 days, you could choose to close out the PIP and just go straight to discipline at that point. And so, bear in mind that the performance improvement plan process, frankly, the disciplinary process, it can be very fluid, and you shouldn't feel like you're bound to stick within certain confines, because you do have a great deal of latitude on how to implement it. Another question that just came in, and I think I addressed this, do you have a recommended length for a PIP? Is 30 days enough? Yeah, definitely. 30 days can definitely be enough. As mentioned, I would be reluctant to implement a PIP for shorter than 30 days, because after all, the idea is to give that employee a chance to improve. Another question, if a manager wants to, see if I can get this here. What I'm understanding the question to be is, if a manager wants to terminate an employee in connection with a performance improvement plan, and there's no formal disciplinary action in the file. I think that's the question. You can certainly use a performance improvement plan as that kind of last stop before termination. I definitely have clients that use them in circumstances where there has been no discipline. That's not ideal, but sometimes we look at the situation and that a performance improvement plan with an opportunity to improve is better than no documentation at all and going to termination. And in that circumstance of no prior disciplinary history and a performance improvement plan, I think that from my standpoint, I would argue that you're in a more defensible position by using a PIP, because you've given that employee an opportunity to improve. You put them on clear notice of what the problem is, and you've also put them on clear notice of what the consequence is. So, again, PIPs, it's just another example of how they can be used strategically, and they definitely can be used, absent any other disciplinary history, but we want to be careful about that. I'm going to try to answer just a couple of more questions here. I realize we're just pushing over time. Another question is that if a PIP is unlikely to be effective, if they're terminated, if a PIP is unlikely to be effective if they're terminated, won't that be held against us that we didn't give notice that they need to make these improvements? If we have told them that they must change this or that they will be let go, isn't that really a PIP anyway? I think that, and I don't mean to be flippant, but I think there are circumstances in which no matter what you do, an employee is going to try to hold it against you. And I think that, if we're giving an employee notice of a performance problem, we've implemented the PIP for a legitimate purpose, we've held ourselves accountable to the PIP process, again, it can be an effective tool butting up to a termination. And again, I understand there are circumstances and twists and turns, but again, using a PIP right before termination is clearly a viable option if we're doing it the right way. Here's a question. You mentioned skipping a PIP if it doesn't make sense. Is there ever a time that it is okay to move to termination without a PIP or a written warning? The answer is most definitely. You know, if for example an employee comes in and you know, approaches a manager and you know, launches off on that manager, slaps them in the face, kicks their desk, knocks over a plant, I'm just making that up. But yeah, of course you can jump to termination immediately depending on the circumstances. There is absolutely no legal obligation to put an employee on a performance improvement plan. You should only do it when it makes sense. You should only do it when you think that the employment relationship is salvageable or there's some other strategic reason why you want to use that PIP. Well, that concludes our webinar. I very much appreciate your time, and I appreciate the questions that have come in, and I hope you have a great rest of your day.